Hi, this is a presentation that I previously gave to a group of taught postgraduate students, and I thought it might be helpful as a piece of background for people attending the Open Data Conference. So this is framed more broadly than open data, but I hope at least you will see how open data fits within a somewhat broader framework. So I entitle my presentation Safely Maximizing Value from Publicly Funded Data. Okay, and I've listed different affiliations here. So this is not really about boasting. This is just trying to explain the context in which I'm coming from in evaluating this idea. So I'm currently the director of the Social Science Research Center, although I will be retiring soon. I'm the lead on knowledge exchange in Hong Kong U, but I have previously played a number of different roles. I was the chair of the Human Research Ethics Committee for a long time. I was the lead on research data management policy for Hong Kong U. I've previously been a chair of the subcommittee on privacy for the Law Reform Commission, and I was previously a member of the audit team for the Hospital Authority for the PCPD. So I have a specific interest and knowledge about hospital authority data. So what's the context of this talk? So I'm going to start with a statement. So this is a statement that said, publicly funded data are a public good produced in the public interest, which should be made openly available with as few restrictions as possible in a timely and responsible manner that does not harm intellectual property. So the only thing in which this is my statement is that I've removed the word research. So this was actually originally a statement about publicly funded research data. So this statement was actually made by the research councils in the UK. So this is the primary funder of research in the UK, so that their context is publicly funded research. But I don't think research is a crucial element of this statement. I believe this statement is appropriate for all publicly funded data. In fact, arguably, it should also cover publicly regulated data, but I don't want to get into that discussion in this particular presentation. So at least I would argue this should cover all publicly funded data. So because this was a presentation for students, I wanted them to think through a number of questions, and I would also like you to think about these questions and see whether you agree with my perspective during this presentation. So this presentation is meant to be somewhat provocative in order to try and help you to think through these issues. So first of all, is this statement justified? So my justification for this would be, if it's publicly funded, then clearly it should lead to public benefit. So the argument is that this public good is about maximizing the public benefit from this public funding. Secondly, as I've just hinted, should it be all publicly funded data rather than just publicly funded research data? Indeed, should it even be publicly regulated data as well as publicly funded data? Thirdly, what does a responsible manner mean? So I'm going to argue it's primarily about privacy and about intellectual property risk. And then there's also the issue, of course, about how does maximizing public value link to being openly available? And if it's not openly available, how can we still maximize the value? So that's something I'm going to talk about in this presentation. And lastly, is tragedy of the commons relevant? So what's tragedy of the commons? So this is a concept amongst lawyers and economists, basically saying the problem is often that the benefit is not to the person who has something, it's to the whole public. So in other words, if I have some data, if I've got some data in my hands, why should I share it if I don't see what the benefit is to me rather than a public benefit? So public benefit is a challenging situation in many situations where the individual who has something in their hands maybe doesn't care too much about public benefit, they just care about their private benefit. So we need to think through about who benefits in these situations. So let's start from thinking about the government. So obviously that's a crucial issue in Hong Kong. What is the government's position? So the government's normal answer to concern about the risks of sharing information is very simple. Don't share it unless required to. even if it's not personal data. And I'm going to talk a little bit later on about the example of police data on crimes at the district level. So we need to understand that Hong Kong doesn't have a government records law or a freedom of information law, which many advanced economies do have. Both of these are currently being considered by the Law Reform Commission, although I point out that freedom of information was first proposed in 1994 together with the Personal Data Privacy Ordinance. So Christine Low and Anna Wu in particular tried to persuade the government in 1994 that we needed a freedom of information law. So this is not, if you like, just a post-handover issue. This is a long-term issue in Hong Kong where we have been behind the curve, even though if we'd implemented it in 1994, we would have been relatively advanced. And as I'm going to explain to you later on, although the Hong Kong government does have a code of access to information, it's very weak and not, frankly, very useful in many situations. So why is the code of access a problem? Well, just to give you some examples, there are some massive exemptions in here. I'm not going to go through these in detail. You can read them yourself. I'm going to give you the presentation for download. I'm just going to highlight the bolded parts. So if disclosure would harm or prejudice the competitive or financial position or the property interests of the government. Well, in almost any situation, it could potentially harm or prejudice the property interests of the government to make data available. But what are the property interests of the government? Surely, if the government is for the people, these should be the interests of the people. So this to me is back to front. Competitive with whom? Whom is the government competing with? Financial position, well, again, financial position of the government should be about what benefits the public, right? And then information could only be made available by unreasonable diversion of the department's resources. Well, what is unreasonable in this context? Obviously, there will always be some diversion of department's resources in order to make information available. So who gets to decide unreasonable? Well, the government does. Well, that's obviously a bit of a problem. If the government themselves gets to decide what's unreasonable, then they can justify not making any information available simply because it requires some resources. And then it also says where disclosure could be misleading or deprive the department or any other person of priority of publication or commercial value. Well, clearly, making any information available potentially makes the department deprived of commercial value. But again, who should be benefiting from this, right? And what this disclosure could be misleading mean? Again, that's a very, very broad exemption. And then information about any person, including a deceased person, unless such disclosure is consistent with the purposes for which the information was collected. Well, deceased people are not covered by the privacy law. They're explicitly excluded. So this is then much broader. So any deceased person means essentially no historical information can be made available if there's any person involved in this, whenever they lived. In other words, even if somebody died 100 years ago, this could be still used as a justification for an exemption. So just to give you a simple example, I did a government-funded research project. The government refused to release the full report. They only agreed to release the executive summary, and they threatened to sue me if I released it myself. Even though this was a government-funded research project, it was not it was intended to be a research project. It was about the use of language in the workplace. So it's clearly of value to employers in Hong Kong, and yet they refused to release the full report, right? And threatened to sue me, claiming it was a commercial interest. But this was funded as a research project through LegCo funding, not as a commercial project. So what about the CE's Election Manifesto? So she actually had some very positive things in her Election Manifesto. She said she would increase the transparency of government information and data. Measures include opening up more government data for social policy research and public participation in policy formulation. Well, I would question whether that actually has happened in practice. I will give some examples in a minute. She also said that she supported an archives law. She said she placed great importance on the integrity of government records. She had a positive position towards passing of law, and the government will follow up on this after receiving the report from the Law Reform Commission, which has still not appeared. And you'll notice there's no mention of the access to information law, which is going together with the archives law. So What use are records if nobody can access the information in those records? So let me just say something about what the LRC proposals were. So this is the proposals that were put out for consultation, not the final version. So these were put out in 2019. There are many problems with the proposals on archives law, including a focus only on government records rather than on the records of public bodies, and no discussion of the principles of transparency and accountability, which in other jurisdictions are the core of a records law, right? It's all about transparency and accountability. There's basically no discussion of these principles whatsoever in the proposals. It's as if this is just a pure administrative issue without any principles underpinning it. The access to information proposals, which came out at the same time, also have many problems. They have a very narrow definition of public bodies, a frankly dishonest assessment of effectiveness of the existing code. If you look at the Ombudsman's assessment, you will realize that their assessment of effectiveness is completely flawed. So dishonest is a very strong word, but I feel that that's in fact an appropriate word here. No reference to open data, no reference to metadata, which is the data about how data was collected, which is essential. It focused entirely on cost and administrative convenience, ignoring principles and that digital distribution is close to free. And it proposed a ridiculously wide exemption for research and for internal discussion, which would mean that much research data would not be available. So I talked about responsible sharing or safe sharing. So for non-personal data, in general, there is very few safety problems, right? I won't say there are no safety problems at all. So for example, if you provide very detailed information about, say, how a police station is set up, you might argue there are some safety issues, or how a prison is set up. So if everybody could get very detailed information about prison security, clearly that would be a potential security risk. But for most non-personal data held by government, there should be very few safety problems. So the primary issue, I'd argue, is really about personal data. And the primary issue for personal data is assuming that it has been anonymized. So in theory, it's no longer personal data. The problem is about protecting against re-identification. And I will say something about that a little bit later. So I'm going to argue that intellectual property here should be an almost non-issue, because for publicly funded data, the intellectual property benefit should generally belong to the community, right? It shouldn't just be for civil servants to determine who gets access to information. Now, I will not say there is no exception to this, but in general, if this is publicly funded data, why should the whole community not benefit from access to information? Now, in fact, unfortunately, even now, the government research contracts still focus on protecting IP rights without any allowance for sharing data. So I spent almost a month arguing with the government recently over a research contract where they insisted that there would be no sharing element in the contract whatsoever. It simply says that even though I did the research for the government, I would have no right of access whatsoever, and I would have to delete all the data at the end of the contract. So even though the government has said all these things in the past, in practice, the contracts they're asking academics to sign, or indeed anybody else to sign, are entirely focused on intellectual property rights without any balancing concern. There is also issues about the trading fund model. So lands registry for maps, or the company's registry, which rely on income from fees to access publicly funded data, which clearly limits the ability of everyone to make the best use of the data. Now, to be fair, the lands registry is making some attempt to change, but I would argue as long as the trading fund model is in existence, there is a problem. So we have to rethink the funding model for government departments which have previously been on a trading fund model, which basically means they rely on fee income, right? So the amount of fees that they obtain may be in the tens of millions of dollars, but compared, I would argue, compared to the public benefit, these are relatively small sums of money, and the administrative cost of these fees is not small. Okay, so let me tell you a little bit of story about why I feel quite strongly about this. So this was a public policy research project I did looking at language use in Hong Kong across different constituencies of different districts. So the tables for this data was no problem. I could get that from census, and they had no difficulty because there was no privacy risk. And the constituency boundaries, in theory, already existed because they'd been prepared for the registration electoral office. However, I was told although I could have these boundaries, I could not share them. So how can you construct maps publicly available without making the boundaries publicly available? Right, so I was told I could have the boundaries but not share them. But I pointed out that the registration electoral office had already paid for these boundaries to be created, and they claimed to be transparent. So after some pushing, much to my surprise, the Lands Department gave in, possibly due to the registration electoral office being embarrassed by the fact that they claim to be transparent, and yet the data that underpins the electoral maps was not publicly available. And I encourage you to go and have a look at these maps. I've given you the link here to have some idea. So these are the 2011 results. I'm soon to make it available the 2016 census results, which are even more interesting because it will have written language as well as oral. So what about sensitive data? So the Personal Data Protection Ordinance report, sorry, I should say the PCPD report, implicitly. So this was the report by the Law Reform Commission on personal data. So that agreed that there were some problems with defining sensitive data because that can be culturally sensitive, and in principle any personal data can lead to discrimination or other negative consequences. So there were some specific suggestions considered for later addition to the ordinance, but the commissioner's paper actually was flawed because they didn't distinguish between the risks from biometrics. So with biometrics, the risk is that they're immutable. So for example, your fingerprint, you cannot change it if your fingerprint gets leaked. Or your retina scan, right, of your eye, also, once somebody has that image, then there's nothing you can do about it. That's one type of risk of sensitive data. The other type of risk is publication of sensitive data, such as your long-term health status. In other words, have you ever had HIV? Have you had other illnesses which are perhaps sensitive because they might link to your sexual activity? So let me now say something about open data. So this was the original focus for this conference, and it is crucial as an element of this. So what are the specific issues about open data? So open data generally means data that is freely available to everyone to use for any purpose other than perhaps illegal purposes. So there may be some statement you cannot use for illegal purposes, but of course once the data is freely available, it's very hard to stop illegal purposes. And generally people can republish it as they wish. So we're accepting that there would be no copyright restrictions or patents or other mechanisms of control. So this clearly maximizes the public benefit. However, it also means we need to be careful that the risk is indeed very low for any misuse, as it's very hard to restrict unethical use once the data is made freely available. And so if that data has ever been personal data, it's often very hard to ensure very low risk because of re-identification risk. So I haven't really explained re-identification risk, so let me give some examples. So for example, if I have hourly GPS location data from your phone for even one day, I can probably re-identify you from that data unless all you did was sit in a very big Starbucks that has many people going in and out. But even then, if I know that you sat in there the whole day, there probably aren't very many other people who sat in that particular Starbucks for the whole day. Or for another example, if I know the exact time and date of admission to a specific hospital, although that may not be quite unique, and in other situations it will be unique because you may be the only person who arrived at that exact time and date at that particular hospital, because other people arrived a few seconds or minutes later. Or for example, if I have the IP address of a website you accessed and I have the exact time of access down to a microsecond, that's probably still sufficient to be a unique identifier. So we can re-identify many individuals even if direct identifiers such as ID card number or hospital number or mobile phone number have been removed already. And again, obviously the more data we collect on each individual, and we will talk a little bit about the e-health records later on, the easier it's going to be to re-identify individuals. So let's talk about a specific example of a very extensive data set. So the census data. Now, in fact, census data in theory covers everyone, but in practice, most of the census data is only on a 1/10 sample. So how does census handle this? Well, generally their attitude has been to destroy all paper questionnaires after input, make statistical tables available for free, and allow secure access to data sets. So that's actually, from some perspectives, a very good and comprehensive response to make maximal benefit from the data. However, this means that by destroying all the original questionnaires, historical research on individual identifiable census data records is impossible. So, for example, in the US or the UK, you can go back and get the individual census data records from a century ago on the assumption that most people from then are dead, and you can look it up. So I looked up and I could find where my grandparents lived in London in the 1914 census, if I remember. No, maybe it's the 1911 census. I can't remember the exact year. And I could see who was living in their household at that time. So that's very interesting to me, so to try and look at the history of my family members. But the census approach does allow analysis of individual records without identifiers, because they do privacy risks on the resultant output from your secure access. So that's still a reasonable balance between the different issues, even though there is this, we have lost some of the opportunities of historical analysis. So what about public registers? So this has become an issue again. So again, if you look at the history of the Data Protection Ordinance, there are access and correction protections in there prior to proposed adverse administrative or private decisions, and matching approval should only be given if the competing social need overrides privacy interests. So with public registers, it was recommended that the use limitation exemption would only apply for the original purpose. So it was agreed that the government would deal with these issues rather than putting all the details inside the ordinance, making it very long and complicated. Unfortunately, the government hasn't dealt with these issues. So the recent problems with journalists accessing the Transport Department vehicle data have made this very clear. And indeed also the problems trying to fix the company's ordinance to deal with the privacy issues, where in the end LegCo rejected amendments to the company's ordinance which would have provided the necessary protections of privacy. So in fact, the government issued a memo in 2000 which they still have not lived up to. So that had guidelines on the protection of personal data in public registers, and it had a whole list of issues that were supposed to be addressed, most of which have not been adequately addressed. And again in 2012, the government restated that putting personal data in the public domain does not make the data available for use for any purpose. In other words, it should be only for the original purpose. So let's look at a specific example, the app called Do No Evil. So this was a key example of a private sector app matching government data sets, litigation, bankruptcy, and company directorship without proper protections in 2013, which indeed got awards from government agencies for being a great example of IT development. But they clearly did not realize that they had not undergone a proper privacy review. So the Privacy Commissioner's Office indeed said, disclosure of litigation, bankruptcy, and company directors' data via the app has exceeded reasonable expectation on the use of this information in the public domain. It's neither consistent with nor directly related to the original purposes of the judiciary. The ORO is the official register. This is about bankruptcy, and the company's registry in collecting the complainant's litigation and bankruptcy data, and hence the company GDI had contravened the ordinance. Okay, sounded all okay and fine, except it was clearly a privacy problem. We agree, because they had matched on name and address and they gave no access or correction. So there's potential for serious negative consequences from matching errors, hence the need for action. But the problem is there was no original purpose stated. So the judiciary nowhere states the purpose, and the company's registry releases the address data of directors without giving any information about what the purpose was. So this was a massive problem. How were people meant to know what the purpose was when it's not stated? So I actually very strongly disagreed with what the Privacy Commissioner's judgment, the basis of their judgment, although I agreed with the conclusion that the app was a problem, saying that they should have known what the purpose was in my view, ridiculous. Okay, so let's now look at another specific example of e-health records. So Hong Kong is very special because the public hospitals records are nearly free. They're very widely used, and they keep very complete electronic records for hospitals and indeed for public health clinics, including sexual hygiene clinics. So it's a very comprehensive data set. The problem is that the legislation for e-health records had a serious flaw, that it said that you can only opt in for all data to be included, which the government chooses to include, or nothing. There is no intermediate stage. You cannot say, I do not want some of my health data to be included. It's either all or nothing. And of course, big data enthusiasts want access to this data, claiming that anonymity removes the risks, but they clearly do not understand re-identification risks. Indeed, if you look at the current vaccination process of the government, they're encouraging you to sign up for e-health records without adequately explaining what the privacy consequences are of signing up to the e-health record system, which I personally consider irresponsible. What about research data? So as I said, this originally was framed in terms of research data. So Hong Kong U has taken the lead in Hong Kong by requiring archiving of research data for new research projects. So it's like, in the government context, it's the equivalent of having a data records law. We say, all new research projects, you must archive the research data, and all research postgraduates who create new data sets must archive their data sets together with the thesis. But the objective is not about sharing. It's about research integrity. In other words, if there's any question about whether your research data is indeed valid or anything has been changed or manipulated, at least we have the original research data to go back and check. So there's no obligation to ever share your research data, regardless of whether there's any privacy risk or of what the benefit might be from reanalysis. And of course, very few people have shared their data so far. So one of the problems, of course, is academics are often very naive about personal data. So for example, in my previous experience, I had colleagues get very angry with me. They had collected DNA samples. They wanted to share them with everyone they felt free to without consent, because they said it's anonymized data, so there is no privacy concern. Well, of course, unfortunately, DNA is an almost perfect re-identification tool. Indeed, not just for you, it may be a re-identification tool for all your close relatives. So, I do want to make clear that the government does deserve credit for what they've already achieved. So data.gov.hk was indeed a good start and has improved greatly over time. The coverage has improved greatly. The licensing has improved, but there are still many crucial data sets missing. So for example, there's almost nothing in there relating to policing or crime. So for example, crime details by district. The police deny that this data set even exists when I try to get access to it through the Code of Information. But the Hong Kong statistics are created by accumulating the crime details by district across districts. So clearly it exists, and I know from people inside the police force they've confirmed that it does exist. So of course you can speculate as to why the police don't want to share it, but that's perhaps for another discussion. So what's this space? In other words, to me, the key question for now is whether the final law reform commissions will be reasonable and whether they will be implemented. Now, I certainly, in my retirement, because I don't believe this will happen before June 30th, will be attending any LegCo panel meetings if I can, and I encourage all of you who care about whether the government keeps good records and whether we can get access to attend those LegCo panel meetings and push very strongly for a very large coverage of both the records law and of the freedom of access law. I think these are going to be really important. So my ending statement, again, I still believe that publicly funded data are a public good, produced in the public interest, and they should be made openly available with as few restrictions as possible in a timely and responsible manner. And I don't frankly believe that the intellectual property harm is a significant issue in most situations. I think that's a distraction. So again, the questions I stated at the beginning. Do you agree with me that this statement is justified? Do you believe that it should indeed apply to all publicly funded data, or indeed all publicly regulated data? What do we think about being responsible? As I've said, I believe that the primary issue is protecting privacy. How does maximizing public value link to openly available? Well, I would argue we need to make sure that startups and other socially responsible organizations, so whether it's commercial value or social value, we need to make sure that people can make the best possible use of this data. And again, we need to recognize academics are not going to share it or of themselves because they see the benefits primarily to themselves rather than the publics of other people reanalyzing those data sets. Okay? So I welcome any questions or comments. I've put my post Hong Kong U email address here, so I encourage anybody who's interested in this topic to email me. So I hope you have found this useful as giving you some form of background to the issues about sharing government data. Thank you very much.